have it. Thank you. And so we now proceed. I will pause for a moment to allow a change of personnel. Are we all sitting comfortably? We now come to motion number 3 on risk-based exclusion. The motion is as on the order paper, and I inform the House that Mr. Speaker has selected the following amendments to motion number 3. As listed on the order paper, amendments O, H, I, J, N, P, C, K, L, M, Q, and D. Yeah, I know it sounds like an eye test. Yeah, it's okay. I'm sure I've got it right. I shall call members to move their amendments formally at the end of the debate. I call the Leader of the House to move the motion.
Thank you, Madam Deputy Speaker. On behalf of the House of Commons Commission, I beg to move the motion standing in my name on the order paper, and I will keep my opening remarks short and try and answer honourable and right honourable members' issues at the end of the debate. The motion before us provides for 4 things: for the House to approve the updated proposals on risk-based exclusion, published on the 14th of December 2023 and modified by the Commission at its meeting on the 18th of March, to agree a new standing order to implement the risk-based exclusion policy, to require Mr. Speaker to appoint a panel to review the operation of the new standing order to report within 6 months, and to allow MPs who are excluded from the parliamentary estate to apply for a proxy vote. There is also an amendment tabled in my name on behalf of the Commission which would enable the risk assessment panel to meet during recess. This is a technical amendment. I'm not in my opening remarks. I'll come back to any issues the honourable gentleman raises. This is a technical amendment required to ensure the proper functioning of the panel and therefore the scheme. These proposals reflect extensive consultation with members, parliamentary select committees and other relevant stakeholders. This includes a debate on the 12th of June last year in which members raised a number of thoughtful points which the Commission has taken into account, including with regards to the point at which risk assessment is triggered. This measure is one of a number of measures that are being reviewed and brought forward by the Commission to improve standards of behaviour and safeguarding. I thank all members of staff and honourable members for their contributions which have brought the Commission to agree these proposals and put forward today's motion, and I look forward to hearing further contributions this afternoon.
The question is motion number 3 as on the order paper. Lucy Powell.
Thank you very much, Madam Deputy Speaker. It's arrived to me rather quicker than I thought, because I thought that the leader would be making a more substantive speech in her opening. But may I first of all thank the Leader of the House for bringing the risk-based exclusion motion for debate and vote here today. I strongly support the principle behind it and the proposal. It's long overdue and, as I will come on to, as it stands, represents the bare minimum of what is required in the interests of safeguarding and good working practices. And I'd like to thank those who've worked to get us to this point, the staff and the trade unions who've been raising and pressing these issues for years, the House of Commons Commission, the Mr. Speaker, who has been long pushing these things, the House committees who've considered and inputted into the process, and all those members who've spoken in the many debates and responded to consultations. When we have these debates, Madam Deputy Speaker, I think we should remember who is listening to us. While the temptation is to make these discussions about ourselves, many of the people watching will be victims of harassment or abuse. They will be looking closely not just at what we say, but also the way we conduct ourselves. At the heart of this is our responsibility to ensure that everyone in Parliament has a safe working environment and that we uphold the highest standards and expectations. That is a far cry from where we were in the recent past. Issues of serious wrongdoing or harassment or bad culture and workplace have been a constant cloud over this place. The headlines bring the entire House into disrepute and add to the erosion of trust in Parliament and in politicians. Parliament is a uniquely strange workplace where the bosses are not employed at all, yet employ others with little oversight and are only really accountable to our electorate, not to an employer or with an employment contract. Members have constitutional rights which allow us to do the job representing our constituents freely and without fear. And we are also at risk of vexatious or targeted attacks. But the way we operate can leave others at risk. This makes navigating workplace issues of this kind all the more complex, yet increasingly necessary. Over recent years, we've made important strides, but we do need to go further. For too long, Parliament has relied on informal processes to deal with serious allegations. Now, through the Independent Complaints and Grievance Scheme, complaints of abuse, bullying or harassment are dealt with quickly and robustly, with profound and sometimes difficult consequences. As the independent review of it out this morning shows, there is now a clear, fair and anonymous route for complaints to be dealt with and resolved. Let's hope this now acts as a deterrent, because we know the best cure is prevention. However, despite this progress, there remains serious gaps. Where an allegation of sexual or violent misconduct is so serious that it's being investigated by the police as potentially breaching a criminal threshold, there is no mechanism at all for the parliamentary authorities to take safeguarding action or sanction until such a time as someone is convicted. We currently rely almost entirely on a voluntary arrangement in these cases for members not to come on the estate. Such voluntary arrangements are only effective until they no longer are, with whips often doing the difficult job of making them work. This is not only a serious safeguarding issue, but Parliament very much out of kilter with most modern workplaces over which we govern and set the standards for. The risk-based exclusion motion we are discussing today is a crucial, if limited, step on the path to changing this. It sets out when a member is charged with violent or sexual offence, a risk assessment panel will consider whether they may pose a risk to the parliamentary community. Exclusion is not automatic, and the motion also contains clear criteria and a process for the exclusion to be lifted. For complete clarity, can the leader confirm that this exclusion procedure would apply to those who are currently under charge? Members affected would also be eligible for a proxy vote to ensure their constituents still have a vote during this time, which I will come on to. The threshold for the police to charge someone with such offences is a very high one and would have only applied to 1 or 2 members in recent years. It's taken a long time to get to this point. The Commission first started considering these proposals back in 2022. It will be important today to get at least something done to make some progress. However, the Commission originally agreed this process would kick in at arrest, not charge, as tabled only a few weeks ago. It was heavily consulted upon, including with the police, staff representatives and others. I supported the trigger being arrest then, and I still support this being triggered at arrest today, and I know many across this House agree. It's more appropriate for safeguarding and ensuring staff are able to feel safe and would be standard practice in other workplaces. Can I thank the members for North East Fife and Birmingham Yardley for their amendments on this matter, which I support. I am concerned that the higher threshold of charge would cover so few cases that it risks discrediting the entire point of the exercise. What's more, had the whole proposal been originally conceived around charge, I'm not sure we would have agreed to either the need for a panel nor for a proxy vote, as they've done in the other place where exclusion is automatic. Which is why, if the policy for risk-based exclusion remains at charge, I am also minded to support the amendment tabled by the member for Amber Valley. During the many recent debates we've had, a number of reasons to oppose these proposals have been put forward. Some members are concerned that a risk-based process prevents members carrying out their constitutional role to represent their constituents. I disagree. The tiny number of MPs this policy is ever likely to affect would still be able to represent their constituents in writing, by tabling written questions, holding advice surgeries, attending meetings and events off the estate, and so on. Moreover, they would be able to vote by proxy, would still be being paid, and would still hold the title of Member of Parliament in every other way. Indeed, one of the shortcomings of this motion is that it doesn't cover constituency offices, potentially leaving constituency staff vulnerable. Second, there are concerns about prejudicing any case and members not being seen as being innocent until proven guilty. But the purpose of risk-based approach is to mitigate the risk of harm and safeguarding for staff, and is without prejudice. Third, some point to the voluntary system that's in place, but what I would say, it's proven to be wholly inadequate for all concerned, and it is not fair to anyone who has the task of overseeing it. Finally, some raise legitimate concerns that police investigations take a very long time where the anonymity of the accused is not protected. I agree. It's been a matter of much debate in this House that the statistics behind prosecution and conviction in rape and sexual assault cases are shockingly bad. And it's no secret that our criminal justice system is failing in this regard. But that shouldn't be a reason for objecting to this motion today. It's a separate matter which needs appropriately addressing by the government. In conclusion, we've come a long way in addressing the culture and bad behaviour in Parliament. Setting a proper framework for the risk-based exclusion of members is an essential, if limited, step in this journey, but it's only a small part of it. I hope that we can all agree that while we've come a long way, we still have further to go in creating a better culture and higher standards in Parliament.
Dame Karen Bradley.
Thank you very much, Madam Deputy Speaker. And I rise to speak as Chair of the House of Commons Procedure Committee. We were asked to look at these proposals and have been asked to look at them several times. The history goes back to, I think, 2022 originally, when we were first presented with some proposals around this, and we have continued to look at the various iterations of the proposals that were put forward by the Commission. It's not an easy decision to make as to when an exclusion should apply. And whilst I support fully that we should have some form of risk-based exclusion, the point at which it is triggered is a matter of debate. And I think there will be arguments that will be put forward by those on all sides that will be very persuasive. I have to say, based on the evidence that we heard in the committee and the safeguards that would be put in place, I err towards the charge point rather than arrest. Charge is a public point. Arrest is not public. And I think that the suggestion that we would have members of Parliament who have been excluded but are not named, they are anonymous still because their name is not in the public domain, becomes very difficult to see how they could maintain that anonymity. People will see that they have a proxy vote. They will wonder whether they are therefore on baby leave or long-term sick. And it will become clear that actually they have been excluded from the precincts. Whereas charge is public, it is known. It is very clear that this has happened, and it is a very high bar. I think we have concerns, and there were concerns in the evidence that we were given around arrest and when arrest might happen. And that arrest on suspicion of could be, and I appreciate, we are talking about serious sexual and violent offences. It is unlikely that an arrest would just be made on a spurious, vexatious accusation, but it is possible. And I think across the whole United Kingdom, with the different legal systems that we have, arrest can be at different points depending on the force and the legal system. And therefore, charge is something that is very clear that there is a very, very serious allegation that warrants this matter being taken further. Of course.
the Honourable Lady for giving way. I hear what she's saying. How does she then answer the charge that we may be hypocrites in this place? Because following the Wayne Cousins...
We can't be hypocrites in this place. I'm sure that the Honourable Lady can find a more appropriate word than that.
We may be inconsistent in this place in our approach to these matters, because when it came to the case with Wayne Cousins and the Parliamentary Protection Police, we have now agreed that anybody accused of serious misconduct in the police be removed from the parliamentary estate. That's accused, not even arrested. How do we square that circle that what we think is appropriate for the police isn't appropriate for ourselves?
I thank the Honourable Lady for her question, and as I say, this is a balanced judgment. There isn't a right or wrong answer here. I am persuaded by many arguments in favour of arrest on suspicion of. However, on balance, I feel that charge, given the jobs that we do, given the role that we have, given the potential for vexatious complaints to be made, is on balance the right place to be. But I am not saying to the Honourable Lady that we won't be accused of inconsistency. We very well might be accused of inconsistency. We're regularly accused of inconsistency. I know that the Right Honourable Gentleman wants to come in.
I'm grateful to the Right Honourable Lady for giving way. Can she tell the House if her committee gave any consideration to the fact that the meaning of what constitutes a charge and what it actually means in terms of procedure is different in Scotland than it is south of the border? In England, it is the initiation of criminal proceedings. In Scotland, that is the decision that's taken at a later stage by the Procurator Fiscal.
The Right Honourable Gentleman makes the point I was actually referring to, that there are different points in the judicial process at which a charge or arrest is made in the different legal systems within the United Kingdom. We have 3 different legal systems, and it can be done at different times. And as I say, this is a balanced judgment. This is not right or wrong. This is a balanced judgment on the basis of what we are proposing here, which is to remove the right of a Member of Parliament to attend the Palace of Westminster, an ancient right that we have held for hundreds and hundreds of years. We are introducing something very unique and very different here, and I think that based on the evidence we heard, the advice we received from clerks, the advice we received from others, charge feels like about the right point to make that decision. Of course.
I'm very grateful. I think where this whole debate has got completely wrong is by being obsessed with exclusion. It is actually about making a risk-based assessment of what needs to be done to make sure, in a certain set of circumstances, completely proportionate to the point and to the severity of the crime that is being considered, to make sure that this place is safe. I really deprecate the fact that this is being called risk-based exclusion. I suspect we'll be talking about very, very few people who might be excluded. But actually, if you had at arrest a proper assessment of the risk and took proportionate measures to make sure that everybody here was working safely, that surely would be a right way to move forward.
I could never resist the Honourable Gentleman, and that is why I would always give way to him. And he again makes a very good point. And there may be that there is a role to have for another process that does that. But for this exclusion process, that this it feels to me that the right point is at charge. Of course.
I wonder whether her committee considered the difference between whether the allegation or accusation relates to a member of staff or another employee of this House, or whether it relates to somebody completely unconnected. Because I could be persuaded that arrest might be enough if it were a question of relating to somebody who worked here, but if it was unrelated and if there was no question of the person not being given bail because risk was assumed to be low in general, then I would come to a different conclusion. So this is another complication that I might ask for her opinion about.
Well, this is not a matter that the committee did consider, but my right honourable friend makes a very good point. And I would say that we need to think of this as a process, not an event. That this can change, that things can develop. We are today deciding whether we introduce a process of exclusion into our procedures, into our standing orders. We may well decide that actually it doesn't go far enough in the future. We may well decide we need another process in the future. I know the Commission has taken years looking at this, and I'm glad we've got to the point where we are finally discussing it and having the chance to vote on it. But as I say, it's a process, not an event.
I thank my right honourable friend for giving way. Did her committee consider, particularly if we go to the point of charge, whether instead of this entire procedure, a simple application by the House authorities to a magistrate's court for conditions of bail would be more appropriate? Because that would not just cover this place, it will cover any risk anywhere.
I thank my right honourable friend, and we did not consider that exact point, but we did look at the interaction with the judicial process and the concerns that there may be around the possibility of a very clever barrister using the fact that a risk-based assessment had been made in some form of defence around fair trial. I'm not saying that would necessarily happen, but it was something we considered, and it is written, it's in one of the pieces of correspondence that we wrote to the Speaker and the Leader of the House on that matter. I'm conscious there's many want to speak, so I will give...
Thank you. I'm extremely grateful to my right honourable friend. I just wondered if she could explain what weight was given in her committee to the fact that, unlike other people who work in Westminster, excluding a Member of Parliament is not just the exclusion of one individual, but the exclusion of the representation of 80,000 other individuals. And that is a very different position, both in effect and historically.
Well, my right honourable friend makes a point, and that, of course, is... relates to the proxy vote, and that this motion does allow for a proxy vote, and I will come on to that in a moment. But we decided, on balance, and there were different views in the committee, but on balance, the correspondence that we wrote was that we felt that charge was the right point, and that we should not have proxy votes, was one of the things we thought, and I'll come on to that, and also that the panel, we were concerned about the makeup of the panel. The other place I note has decided charge is the right point, but they don't have a panel, so this is one of the areas that we did consider. And we were also very concerned about interaction with ICGS. They're two different processes. ICGS is not involved the police, but the police could be looking at the same complaint. We were very concerned about putting people off going to ICGS, where the anonymity is absolutely crucial and vital, if there was at the same time some form of risk-based exclusion because of a point in the judicial process having been identified and the risk-based assessment being decided to exclude the member. The other point that has been made, it's been made by many, is that the exclusion would not cover the constituency. And if anybody is a risk to the public in that way, then we should not stand by and allow them to continue to carry out constituency surgeries, visit schools, nurseries, places with vulnerable people, visit people's homes. Surely, if somebody is a risk, they are a risk, and they should not be able to carry out their work in their constituency the same way. But this proposal does not cover that. On proxy votes, I think it is worth us just explaining why the committee was very nervous about the idea of giving a proxy vote to somebody who had been excluded on this basis. And maybe it's because in the committee we see proxy votes as a privilege. We have agreed that a proxy vote can be given to those on baby leave and to those with long-term sickness. But one can't get a proxy vote for bereavement, for a sick child, for any matter of issues as to why one may not be able to attend this place. But we would give a proxy vote to someone who has been excluded on the basis that they are a risk to being in this building. That doesn't sit comfortably with many members of the committee, and that was the decision the committee took, that we would not support the proxy votes. I just want to...
I apologise for intervening a second time, but I want to come back to the point made by my right honourable friend, member for North Somerset, who made quite rightly the point that his constituents are being penalised here. But one of the risks of the proxy votes, it persuades people, oh, they're not being penalised. In practice, what we do here, we've seen it with the post office, where actually being here and representing people is the important thing that's being stopped by the president.
Absolutely, my honourable friend is absolutely right. But excluding the voice from these benches is a very severe punishment for constituents. I just want to make one final point in my role as chair of the British Group of the Interparliamentary Union, which is that we have agreed that we will follow whatever is decided by this place in terms of travel, and that outbound delegations will not feature anybody who has been excluded on the basis of a decision taken by the panel. So that is something that we will make sure is upheld, and I believe the other interparliamentary groups are looking at the same thing. So to conclude, Madam Deputy Speaker, and I realise I've been indulged in the time I've taken, but on balance I support what the Leader of the House has put forward, and I will be voting in favour of that this evening.
SNP spokesman Deidre Brock.
Thank you, Madam Deputy Speaker. When the House initially debated the Commission's proposals last summer, I challenged members who like to refer to this place as the mother of all parliaments to make good on that epithet by ensuring that we lead by example and establish best practice. So I'm going to repeat that call today. These reforms are first and foremost about taking real and tangible steps to protect and support staff and indeed other members through mitigation measures. In the development of the proposals, as the Leader pointed out, there has been widespread discussion and consultation with a number of organisations and individuals, and I would like to pay tribute to all those who had contributed, particularly the House of Commons staff who have worked so carefully and so diligently on the proposals over many months. My feeling is that this has dragged on for so long, completely inappropriately. At their heart, these reforms are about protecting staff and the wider parliamentary community from harassment and abuse. They have been long called for and very significantly delayed. I believe the motion in January struck the appropriate balance between the rights of staff and the parliamentary community to protection from harm, the right to due process for the individual implicated, and the rights of that individual's constituents to democratic representation. It seems now, though, that the balance has been shifted away from the protection of staff by the government, raising the point at which a risk assessment takes place from arrest to charge. Now, it's clear there are a range of views on the correct threshold to begin that risk assessment process. However, leaving to one side for a moment that specific trigger point, it is important to stress the main responsibility of the panel would be to consider the nature and severity of the alleged misconduct, whether there is a safeguarding concern, and to determine the presence of a possible risk factor. And referring to the Right Honourable Lady for Staffordshire Moorlands and the chair of the committee there, just the Parliament's authority, as I understand it, and this is something we've discussed in the House of Commons Commission a lot, doesn't stretch to constituency offices. It's certainly all the members of the Commission are aware that that is something that we were not able to take into account. And that is perhaps where the ICGS process, the latest review of which was revealed this morning, which has some really excellent recommendations which will help to tighten up that ICGS process, I think will have some effect too. It's worth noting a number of mitigations would be open to the panel on a case-by-case basis. These might include, for example, preventing one-to-one contact with the member, preventing members from accessing bars on the estate, complete exclusion from the parliamentary estate, or indeed taking no action. And the panel would also be informed of any existing voluntary arrangement between the member and their whip to stay away from the estate. Crucially, those undertaking that risk assessment process, I believe, would not take any action that could potentially compromise a police investigation or undermine any prosecution. The panel wouldn't be given the name of the member being risk assessed. At no point would it be made public that information had been shared by the police about a member, or that a risk assessment had been undertaken, or that a member had been excluded. The proxy voting... Yes, yeah.
Thank you very much for giving way. I think very much for me a lot of spins on the formation of the panel and the training of the panel. And I was looking at one of the addendum to the motion, which was saying it's anticipated it would be an MP and probably 2 deputy speakers forming the panel. What training do you think they may need to be able to navigate such complex legal sensitivities? And does she also have concerns that I do with regards to the role of the speaker as an office in this process, particularly what would happen if the speaker was a victim in a case where this was going forwards, or indeed the Speaker was charged, or the Deputy Speakers, how would the Speaker recuse himself or herself from a conflict of interest in that situation?
Well, I mean, the motion does mention the assistance of the Council to the Speaker, the Director of Parliamentary Security and other such members of the House Administration as it thinks fit, and I believe that would be the case regardless of what we agree on today. In terms of the Speaker being involved in, I mean, that would be, I'm sure the Chair of the Ways and Means is being suggested as a possible member of that committee, and then the Deputy Chair of the Ways and Means Committee as well. And then a member, I realise there's an amendment coming up with regard to whether or not that member might be a member of Cabinet or Shadow Cabinet. My personal feeling is that that does not concern me. I mean, we should all think that all of our members are fit to serve on such a committee and be prepared to do so. So just heading back to the proxy voting record, again, would not state the reason for a proxy being granted. Information would be shared with the minimum number of officials required to implement an exclusion under a strict commitment to confidentiality, of course. So with those essential protections, the SNP believes the motion should be brought back in line with the January version, which would more closely implement the Commission's proposals. We will therefore be supporting the amendment in the name of the member from North East Fife. Again, we mustn't lose sight of the fact that these proposals are about protecting staff or fellow MPs. To raise that threshold further, I think, severely limits the ability of these proposals to succeed in doing so. Look, the length of time this has taken, frankly, shames us all. Westminster is often accused of being an institution stuck in its ways and unable or unwilling to change. Please, let us make sure that is not the case today.
Sir Jacob Rees-Mogg.
Thank you, Madam Deputy Speaker. I accept and believe that it is important that we have some means of protecting people in this House. This is something that we have been trying to do, and the introduction of the ICGS has helped in that process to make people confident that there is a route through which they can complain and where they can have their best interests reassured and safeguarded. The problem with this motion is that it is simply unconstitutional. If we want to go down this route, we need to legislate for it. From time immemorial, actually since 1340, unmolested access to this House has been the right of every member. And that's for a very good reason. These privileges are not for us as individuals, but they are, as my right honourable friend, the member for North Somerset, said, because of the 80,000 people we represent. And the ability to take away that right of attendance has always been held exclusively by the whole House. There is one exception I can think of to this, and that is in 1648 with Pride's Purge. We get some chuntering from Rhondda, as we so often do. Yes, the Speaker may name somebody and ask them to withdraw, but for any suspension, that requires a motion. It is a divisible motion. We have expelled members, historically. We have suspended members and continue to do so. That is a vote of the whole House. But if we expel members, that member has the right then to stand for Parliament and be sent straight back again. And that is a fundamental right, not of us, but of the people who sent us here. Now, the John Wilkes case is a very famous one, when the House disliked an individual member and expelled him, but he stood and he succeeded and he was returned, and it's politically, of course, of great importance. Now, in this instance, we are suggesting that a small committee will have the power to deny constituents representation. That is not within the power of this House, unless it acts as a whole. A small committee cannot deprive members of the right of attendance. It is a right, as I say, that goes back to 1340, and the only way to override such ancient rights, this is the whole basis of our system of common law, is by legislation, not by motion. And this, of course I'll give way.
honourable gentleman for giving way. He is, of course, right about the constitutionality of this, but, of course, we all know that in practical terms, in recent times, things have been done differently and that people have been excluded by agreement, however obtained from the whips. Surely what we have here is something that would be more transparent and would apply with equal measure to everyone.
Well, the right honourable gentleman says that because a member has agreed not to come in, that is the same as banning a member from not coming in. That is clearly not true. And this could be done by legislation. It wouldn't take very long to turn this motion into legislation, and it would be the proper constitutional way of doing it. It's also, to my mind, entirely ineffective. We know that the Sergeant of Arms' powers of arrest are pretty much phantasmagorical. We no longer believe that the Sergeant can go, and I'm sorry to embarrass the great Sergeant who is sitting in his place, a most distinguished figure at the moment, but we know that the idea that the Sergeant can turn up and arrest somebody for failing to appear at a select committee is pretty much a theatre rather than effective threat. We know that our powers, ancient powers of imprisoning, are no longer there. So what happens when this person excluded by this small cabal decides to turn up? What are we going to do? Have a vote of the whole House to expel him? The proper process in the first place. Or what if, I'll give way to the honourable gentleman from Rhondda.
Notwithstanding his previous remark, I was mostly going to agree with him about what he was going to say, because I think there is a problem here. And the Standards Committee, when we reported on this, though we made the point that exclusion is very much the very last thing that should be considered, I think in most cases, most members in these kind of situations would choose to accept the decision voluntarily. However, we also said that if a member chose not to, then the House should vote on whether the member should be excluded. Would he be happy with that process?
Entirely agree with the honourable gentleman. For any exclusion, it must be a decision of the whole House. That is our most ancient constitutional right. And the idea that it can be stopped by 3 people, even, Madam Deputy Speaker, as distinguished as the Chairman of Ways and Means, is not in the spirit of our Constitution. I'll give way to my right hand friend.
Is the substance of what he's saying, beg your pardon, Madam Deputy Speaker, is the substance of what he's saying that if we enacted this procedure, then it would be subject to challenge in the court?
I'm saying it would be ineffective because I think an honourable or right honourable member would simply still maintain the right to turn up, and there is no power to arrest that person when turning up, and therefore what do you do next? And what do you do if a person so offended by this, so outraged at the allegation, says, well, I'm going to call a by-election and stand for Parliament and be returned? What do we do? There's a general election coming in the next few months. If a member subject to this is reselected by his constituency association and is returned, by ancient principle, a member who is returned cannot then be barred for something that happened in the last Parliament. We're not going to start, are we, saying that the people of constituency X have sent somebody in, duly voted, who we suspended in the last session and we're going to resuspend? We will remember, just before the last general election, the issue with Keith Vaz, who was subject to a report that was not entirely in his favour. And everyone recognised that that suspension could not carry over a general election. I give way to my honourable friend.
I'm most grateful to the right honourable friend in giving way, and I have immense respect for him and his knowledge on constitutional matters. Can I ask him this specific question? And he's been the Leader of the House, and he's done an excellent job in that regard. Why does he think the government is taking forward an unconstitutional measure rather than apply the due course process by having the House of Commons make this decision from his knowledge as a former Leader of the House of Commons?
Well, because, Madam Deputy Speaker, we've got confused about the limits of exclusive cognizance. This House does have exclusive cognizance about its own affairs, but acting as the whole House. Look at the Bradlaugh case, the exclusion of Bradlaugh. That is the action of the whole House. What did we do when Bobby Sands was elected to Parliament? We changed the law so that people subject to a criminal sentence could not stand for Parliament. We didn't try and do it by setting up some approvals committee that would decide who could put their name forward or not. We followed a proper constitutional process. And to answer my honourable friend, I'm absolutely astonished that our learned clerks, who must have advised on this, have allowed such an extraordinary power grab by standing orders to undermine a fundamental of our constitution. And I know members of Parliament talking about privilege sounds as if they're talking about themselves, but no, it is of our constituents to be represented. And they are not only represented by votes, indeed most of the time they are least represented by votes, because they go the way of a government majority with one more or less not making a ha'porth of difference. They're marginally represented by written questions, but not much. I mean, I've given answers to written questions, and sometimes they seem to be as unilluminating as possible. I always tried to improve the illumination where I could. But the real representation is in this very room. It's not even in Westminster Hall or in committee, it's in this great cockpit of debate. And taking away that right by a cabal is against the Constitution. Now, I just want to make a couple of little points about the proposal. I don't have a strong view on whether it should be arrest or whether it should be charged, as long as it's done in a proper constitutional process. I think that it would be perfectly fair even to say that that were automatic if it were done in a proper constitutional process. That's not really the issue. But I do think what is proposed currently is deeply unfair. I point to two things. One is the panel would not be given the name of the member being risk assessed. Well, dare I say, tell that to the Marines. We know in this place it is inconceivable that a panel of 2 deputy speakers and a panjandrum would not know. We'd all have been told by the lobby correspondents. That's how I find out everything that goes on here, usually from the Mail on Sunday. They have a hotline to what is going on, and they know. And you'd know very, very soon if you were on that committee. So that seems to me to be phony and not recognising reality. And then members must not lobby the panel. We carefully considered whether a member subject to risk assessment should have the right to make representations. If you are being risk assessed, how can you maintain that you are low risk if you're not allowed to represent yourself? I think this is extraordinarily unfair that you will be tried in absentia by a cabal undermining the rights of your constituents. Madam Deputy Speaker, if we want to do this, let us find time for legislation and let us do it properly.
Sir Chris Bryant.
Thank you very much, Madam Deputy Speaker. It's strange sometimes to agree so much with the Right Honourable Member for North East Somerset, and I think he's a bit shocked that I'm agreeing with him as well. I see he nods. But I just want to return to two central things. First of all, this is about Parliament being like every other workplace in the country. Of course, there are ways in which we are exceptional, and we often emphasise those perhaps too much. But actually, what was fascinating when we debated the original proposals from the Commission in the Standards Committee was the lay members of the committee all saying how much in every single line of work that they were in, this would be absolutely standard practice. In various different ways in different organisations, but certainly in every part of the public sector and in any major employer in the land, this kind of process, in some shape or form, would be absolutely standard. And so what we're simply trying to do is make sure that this workplace, like any other in the land, is safe, not just from external threats, but from behaviours that could put staff, members of the public and colleagues at risk. That's what it's about. It's secondly about the assessment of risk. The assessment of risk. How serious is the risk in any given set of circumstances? And those circumstances, heaven knows, could vary enormously from one case to another, from one person to another, and taking then proportionate and only proportionate measures to deal with that risk, to mitigate that risk, as any responsible employer and workplace should surely do and would be required in law to do in any other workplace, would be required in law written by us to do in any other workplace. But it's about the assessment of risk and the proportionate measures to deal with that. It is not, in my mind, and I think it's a terrible shame that it has been billed as such, about exclusion. Exclusion should be, as it is in nearly every other business, the very last point that you would go to. And would be at the extreme end because you had made an assessment that the risk was relatively extreme. This is about the many other things that could be done way short of exclusion. So, for instance, one of the oddities about this building and all the buildings on the parliamentary estate is that we often work as an MP with a single member of staff or two members of staff behind a big oak door. Somebody might want to make an assessment, a risk assessment, if a member were, I would say, arrested for a sexual or violent crime relating to a member of staff. They might want to make an assessment that that member should no longer be in that kind of office, but their office might be one shared with other members of staff or other members of Parliament or in a more visible space. That might be the perfectly proportionate decision to be taken, which could be done entirely without the public knowing and entirely as a neutral act. I think this is a really important point to this. The Court of Public Opinion has no formal rules of evidence. It operates entirely to its own agenda and very rarely, in my experience, actually delivers justice or anything approximating justice that we would want to consider to be so. And that's why it's so important that any measure that is taken, preferably any measure, notwithstanding the point that was made about how rumour spreads around here, any measure that should be taken confidentially. I think in nearly every case it will be taken with the agreement of the member concerned. And also, it should be considered an entirely neutral process. And my worry about this obsession with exclusion as the end point of what we're looking at is that that starts to look like a punishment rather than a neutral activity. And that's why I think, actually, in nearly every case, if the assessment, I will in a moment, if the assessment of the panel were that there was a significant risk that could only be mitigated by a suggestion of exclusion, I think the member would be very well advised and would nearly, or in any set of circumstances, would choose to follow the advice that they would do so voluntarily. But I do agree with the Right Honourable Member that in the end, it must be a matter for the House if there is to be an enforced exclusion. Otherwise, I think there's a danger that we bring the whole process into disrepute and it wouldn't last for more than 5 minutes. Of course, I give way to the Right Honourable Member.
The gentleman is making some interesting points. I have two concerns about this process. One is abiding by our long-standing rule of innocent till proven guilty, and two, that the people being penalised by this are our constituents, not us. Does he imagine guidelines for this panel which take those two things on board in the way he's just described?
I think it's perfectly possible to do that. I can imagine many, many different circumstances where somebody was arrested for a violent or sexual offence, where the panel would decide that they weren't going to go down the route of exclusion. The member would still be able to take part in debates. The member would still be able to be present. It's just that certain other factors would be considered, such as saying you can't go on foreign travel on behalf of the House. You can't go on travel in the UK that is paid for by the House. You can't participate in IPU delegations. You can't use the bars. And we're going to rearrange your offices. And all of those things could happen entirely without disrupting the members' ability to represent their constituents to the fullest possible degree. But as I say, this is always about assessing the risk in the specific set of circumstances and then mitigating those risks only in a proportionate way. And in most cases, my suspicion is that exclusion would be disproportionate and therefore not necessary, which is why I think it's unfortunate that it's couched in the way that it is. Oh, yes, of course.
I thank him for giving way, but I'm slightly confused because I think the points he's making are excellent points, and these are all very good things that we should consider. But the The motion is specific to say that the panel will decide on appropriate measures to mitigate any risk, and any such mitigation may include one or more of the following: exclusion from the estate, from domestic travel and from foreign travel. It doesn't talk about exclusion from bars or exclusion or changing offices. I think if we were talking about how we might mitigate the risk, then we may all be in a different position.
Well, I don't think the motion doesn't preclude those things either. And in fact, when the first report that was produced by a committee was by the Standards Committee and we took evidence, it was interesting. We said, first, we proposed that the power to exclude members from the precincts should form only one part of a wider formalised risk mitigation process. The evidence we have heard from comparable bodies, including the police, suggests that interim suspension is normally a last resort. And indeed, we went on further to say the House Service could, for example, if it were thought necessary and appropriate, I would add, and proportionate, move the MP's member of staff to an office shared with other staff or allocate the MP an office which has a higher degree of visibility. In fact, of course, all of these things could happen perfectly easily without the motion and could happen now. Just a couple more points. The first, the issue about arrest or charge. I do find it problematic just to land on charge. I think that is very late. It's much later than any other comparable body in the public sector or in the private sector in this country. It is not comparable with the law of the land in terms of what most employers would have to do to be a reasonable employer. I would say it's important that it's about the proportionality to, first of all, the crime itself. In one sense, that's already met by the motion because it's about whether it's sexual or violent crime. But also, the panel might want to consider, is there one instance that we're talking about, or are there several allegations? Secondly, is it one arrest, or have there been two arrests? Have they been arrested under caution? We might also want to... There are various other stages that you get to long before charge. So, for instance, police bail. Would it be appropriate... are we saying that we shouldn't even consider that, where somebody is bail on police bail? That seems very odd to me. I would think that is us falling short of our our duty. I would also say that they should consider the individual's cooperation, because if the individual member is being very cooperative, I would have thought that would suggest that you don't need to take major further processes or measures into consideration. And then the point that I think was made by a member earlier, I can't remember which it was, which is, well, who the person is that we're talking about. If it's a member of staff working in this building, presumably one would want to assess that the risk was higher and that therefore one needed to take further mitigatory measures into consideration. Two final points. Oh, all right. It was going to be trying to be final, but...
Point, he talks about bail, but presumably the police bail could instill a condition that person should not go within a certain distance of the person who's made the allegation, and so therefore it doesn't need this particular process. The police are perfectly capable of putting in those conditions on police bail.
But let us say, for the sake of argument, it is only for sake of argument, I'm not referring to an individual case at all, but the Member of Parliament is... the allegation is that they have in some way sexually assaulted one of their or another MP's members of staff here. There are other members of staff in the building. So the police bail may refer to whether they can approach that, the person who's made the allegation, but it wouldn't be able to deal with all the other members of staff who operate in the same purlieu here on the estate. And that's why I think taking the proportionate measure is important. I did want to ask the Leader of the House earlier. It was a simple question about her own amendment. And I know it's very, very technical and tiny, but her amendment says that the panel would be able to proceed during an adjournment. Would it also be able to proceed during a prorogation? I should be able to answer later. The final point I make is the Right Honourable Member for North East Somerset is absolutely right. And the Standards Committee, we made this point ourselves several times when this was being debated from the first set of proposals. In the end, a mandatory exclusion of a member should be a decision of the whole House. I think that would be a relatively easy thing to add to this process. I note the Right Honourable Member had an amendment which has not been selected, which, for whatever reasons, I don't mind. But I do think it would be cleaner if you had a process where, in the main, if we were moving to exclusion, that the member would normally be expected and would probably, I think, cooperate. But if they chose not to, then it would be a matter for a motion of the House which should be taken without debate and without amendment.
Order, I will have to impose a time limit of 7 minutes. Nigel Mills.
Thank you, and it's a pleasure to follow the honourable gentleman. I think I agree with most of what he said. I think that's an old joke when you ask for directions and the answer is don't start from here. I think given a fair choice, I wouldn't be starting with the motion we have in front of us. But I do actually support the idea that this House should be able to exclude somebody who has been accused or charged of a very serious offence. I think that's in the interests of the safety of people that work here and visit here and in the reputation of the House. So I do, I think, support the principle. I think there are various issues with the actual motion we have in front of us, which appears to have been written for a process that should apply when someone's been accused of something or arrested for something, and has ended up being when somebody's actually been charged with it. And I'm not sure, actually, if you were really starting from scratch and saying, what should we do if a member is charged with a violent or sexual offence, I'm not sure you would come up with the process that we have here. So that was the logic of the amendments that I've tabled, which seek to say if somebody is actually been charged with that situation, they should just be excluded until that process has either been resolved by the charges being dropped or by them being acquitted or by them being convicted. It's hard to see, based on the experience we've had of people choosing to self-exclude themselves, that the panel would ever meet and choose not to exclude somebody who'd been charged. It seems extraordinarily unlikely. So what is the advantage of having the panel in that situation, other than adding in some level of discretion and then some risk that what is reported in the public is the House thinks this person's been charged with something so serious they have to be excluded, and somehow we don't think this person's really guilty so they haven't been excluded, and it somehow taints the process for no advantage. So my suggestion is that if the Honourable Lady Opposite's amendment is not carried and this process stays applying solely on charge, that we just scrap the panel completely and then the person is excluded until the whole process is resolved. I think that is fairer, is neater, is more clearly understood, and I think would be a better situation to have. Now, I really do wish, actually, that this process would be a lot quicker, that from accusation through to arrest, through to charge, through to conviction or acquittal, it would not be taking a year or 2 years, in which case I don't think this would be such a significant process. It would be somebody would be out of here for a few months at most, not a few years at most. But that's not the world we appear to live in. That's why I just think having that clarity so everybody knows the position would be better than having the panel. Now, on a few other points, this House appoints members to the Standards Committee. It elects the chair. What we have here is actually a more serious process where someone can be excluded for a very long period, effectively by members who have not been elected by the House for that purpose. Now, I think you can argue that when the House elects deputy speakers to a very serious position, that is a reasonable part of their role. I don't object to them forming part of the panel. But I'm not sure that the choice of the third member and possibly the casting vote, being a member of the Commission, is a very sensible idea, because the Commission is a member of the Cabinet, a member of the Shadow Cabinet, a SNP appointed person, and then effectively 3 others appointed by the government or the opposition. Now, we've generally tried to steer clear of having the government exclude members from Parliament. I think Somerset would strongly agree with that. So I think that was a terrible choice of who the casting vote might be. It should have been the liaison committee or a member of the panel of chairs or somebody who is senior in the House, has had some kind of endorsement from the House but isn't actually tainted by being a government appointee. Now, I think in evidence to the Procedure Committee, both the leader and the shadow leader both said they wouldn't want to be on the panel in this situation. So that's down to 4 members who could actually do this work. What if one of them is accused? What if one of those is the victim? How do you form this panel? So I think perhaps when we come to review this in future, we could find a better way of doing that. And my final point is on the proxy vote. Now, I think it would have been fair enough if you were doing this at accusation or arrest to say, well, somebody may not be guilty, may not even be charged with this. Excluding them completely would be the wrong thing. Let's at least give them their vote. And we have had a parliament in recent memory with a majority of very small amounts where an exclusion in these situations could have actually changed the result of some votes. So I could see a logic for a proxy vote in this situation. But can anybody really see the logic of a proxy vote for somebody who's been charged? We don't give proxy votes to people who are representing this House on other assemblies around the world. We don't give proxy votes to people who are on official House select committee visits or other official business. But we would give a proxy vote to somebody who is in a courtroom, in the dock, on a trial for rape. It is a ridiculous idea. I mean, I just think if we believe doing this at the point of charge is right, then they should be excluded and then they should have effectively no role until they have their name cleared. So I would urge members, if Honourable Member Opposite's motion is not carried, let's scrap the panel that adds nothing and makes the situation worse and not have a proxy vote. I think that would be a terrible tainting of the House's reputation.
Chamberlain.
I want to start by referencing the foreword of the ICGS report that has been published today, and I commend Sir Paul Kernigan for it. In paragraph 3 of the foreword, it says, a scheme like the ICGS must recognise the different working cultures and constitutional requirements, whilst at the same time contribute to a non-negotiable objective of helping to deliver a modern environment in which everyone is respected and valued. The Royal Military Police's motto is Exemplo Ducamus, by example shall we lead, and I have taken the view that Parliament's internal arrangements should also, as far as possible, lead by example, and I have consciously sought to make recommendations that are both practical and reflect the highest possible standards. And I'm very conscious, Madam Deputy Speaker, that that is talking about the ICGS, which is a different process, but I do think sometimes that when we end up talking about dates such as 1340 and 1648, I'm not sure that people necessarily think that is relative to today. My amendments are about safeguarding, and I'm very grateful that the Chair of the Procedure Committee, although she disagrees with me, recognises that that is a key point of contention in relation to the motion that we are bringing forward today. When we last discussed this in a general debate, we were talking about the proposals in relation to arrest. They have now been changed to charge, and my amendment simply seeks to get the view of the House on what is the right point, and I appreciate that there is a balance to that. I also think that the other bit around consultation mechanisms, we've talked about evidence given to the Procedure Committee, the Standards Committee, the Commission. I stand here as a member of the fourth party in this House, and I think it's interesting that I've had support for my amendment from other smaller parties as well. I think it's important when we are debating these matters that all voices are heard. Now, I am conscious that people are also very quick to point out that we are not employees. And indeed, as a former police officer, I was also not an employee then. I was appointed and I swore an oath to serve. But we do have responsibilities to our own employees as an employer. And indeed, I should mention, Madam Deputy Speaker, I was a member of the Speakers' Conference in that regard too. And I think the public do take a view of our employment status in that they recognise that we are not employees. But I do agree with members who have made the point that as far as possible, we should be trying to align ourselves with modern work places and practices, and indeed the laws that we pass here in respect of this place, in respect of those places. Where employment terms and conditions, or MPs' terms and conditions, as it were, have caused issues in recent years is when we have in this place perhaps overemphasised ourselves as being exceptional and unique, and forgetting that we are not here just simply to represent our constituents and peers, but we are actually representatives of those constituents and peers. We are those people too. And if we don't encourage people to think about MPs like that, we will never get the diversity and representation in this place that we want. And I think the public are less concerned about us exercising our rights since Cromwell, but that we should be thinking about how we minimise the impact on representation. And I agree with Honourable Member for Rhondda in relation to the fact that exclusion is one of a series of measures that this motion is talking about and may be only applicable in a very small number of situations. It is about risk and it is about safeguarding. And I would refer to an email that I received from Ken Gall from the trade unions here in the Commons, where he did, and I think the Honourable Member for Walthamstow referred to it as well, where following the publication of the Angelini report, senior House officials, including the Speaker, met with the Deputy Commissioner of the Metropolitan Police to discuss the fact that Wayne Couzens had worked on the parliamentary estate, and the House released the following statement, that the PADP leadership also now automatically informs Parliament's Director of Security about serious disciplinary issues, and that any officer accused of gross misconduct is automatically removed from working on the parliamentary estate. I think all of us would argue that that was proportionate, necessary and a risk-based response. But I think we're at risk here of saying that if the risk posed by a man accused as a police officer of serious sexual offences is unacceptable when that man is a police officer, why is that not the case when the man in question is an MP? I also want to refer to the comments made by the Right Honourable Member for New Forest East. I think it should be part of the safeguarding assessment that we make, that we think about the full circumstances of the case, and it may be appropriate that you take a different approach when the offence is in relation to somebody who works here on this estate and somewhere external. And why, for me, arrest not charge? Because I do want it to align with other workplaces. And I think it's really important that we remember that this workplace, the majority of people who work here are not MPs or members of the other place. They are members of staff. This is their workplace too. And it also aligns with the Government's own external statements of intent, particularly in relation to violence against women and girls. And again, referencing something I received from Ken Gall, he points out that the Government's response to the Government Equalities Office consultation on sexual harassment in the workplace referred to adequate legal protections and prompting employers to take action to prevent harassment. I am not sure how not excluding from the workplace a man arrested on suspicion of rape would not fall into the category of employer not taking all reasonable steps to protect women. The House is not an employer of MPs, but it is an employer of others. And I finally want to talk in my remaining minute about the role of the whips and the politicisation of the process. Voluntary exclusion happens now. The higher the bar is, that allows for more politicisation of this process. The Right Honourable Member for North East Somerset talked about knowing from a panel exactly who it was. In terms of those voluntary exclusions, frankly, we know the people that have voluntarily excluded themselves from this estate on that basis. Having the bar too high actually negates some of the safeguarding measures that we might try to take. And I just want to say, finally, as a former police officer, I think the only one taking part in this debate, arrest on suspicion doesn't just take place on the basis of an allegation. Yes, some vexatious complaints do occur, but what message do we send from this place if we say that our concern for this is actually more important than safeguarding? If balanced, as the Chair of Procedure says, it is important. And finally, I've had several people, members of staff, come up to me today and say thank you for tabling my amendment. I'd ask those thinking of voting against my amendment to think about the message they are sending out with this place.
Sir Philip Davies.
Thank you very much, Madam Deputy Speaker. I want to rise just to make a few... I absolutely agree with my right honourable friend from North East Somerset, as I so often do. This is a very unsatisfactory process, to say the least, and I endorse everything he said. We are where we are in terms of this particular motion, and there are a couple of things that I just want to mention in it, and it relates mainly to this debate about whether or not this should apply at arrest or whether it should apply at charge. I very much agreed with the comments from my right honourable friend, the member for Staffordshire Moorlands. I think she was right when she said that it finds the right balance to do this at charge, partly because of the issues raised about our constituents having a right to be represented in the House of Commons, which should be something that is something that we shouldn't forget, but also the time it takes for these things. It's not just a hypothetical that somebody could here be deprived of being here because they've been arrested even though they've done nothing wrong. This has actually happened, and they've been excluded from here for a substantial amount of time. I mean, are we completely blind to those situations? We should be completely aware of that. We mustn't allow that to happen again. And I have to say that I think the Honourable Member for Rhondda was unusually naive in his view about what might happen if we had the situation at arrest. He seems to think that if we had a panel meeting at arrest, that what would happen is that exclusion would be a last resort, that a whole suite of other things would be gone through before we got to that. I mean, to be perfectly honest, he's been here long enough to know that that's an absolute load of old tripe. He knows full well that the moment somebody would have been arrested, this panel would be, well, we must be risk averse, they'd be excluded straight away, and I guarantee to the honourable gentleman as well that if they weren't excluded straight away, there'd be an awful lot of people in this House demanding that they may be excluded straight away on the basis of arrest. And if he doesn't think that that's the case, then I'm afraid he's completely and utterly out of touch with what goes on there. I'll give way to the honourable lady.
Very grateful for giving way, given that I've just spoken. Can I ask what assessment he thinks the whips currently make on that same basis?
Well, the point is that is a voluntary process. And as my right honourable for North East Somerset has made clear, if somebody feels that that is not a suitable process, they can come in here. This is about us formally excluding people from here. That's a very different issue altogether, and it's one that we shouldn't take lightly. And I suspect it's being taken, I suspect, too lightly. I just want to... I won't, because other people want to speak and I don't want to take their time. There's two other points that I want to raise. And my honourable friend from Amber Valley is absolutely right about the fact that this motion was originally tabled when it was about arrest, and they've just changed the word to charge but kept the rest of the motion in place. Which is completely unsatisfactory. Now, personally, for the reason that I've given, I would get rid of the panel altogether, because I suspect the outcome will be the same on every single thing, whether it's arrest or charge, to be perfectly honest. I'm not entirely sure what the point of the panel is, but he's absolutely right that where it is charged, the point of the panel is completely unnecessary, and we should get rid of that, and I would agree with him about that. But I just want to speak... go on, as it's my right honourable friend, I will.
I actually think my honourable friend from Amber Valley's amendment is more constitutional, though still far from perfect, because it is a decision of the House to exclude under certain circumstances, rather than the decision of a House to delegate exclusion. So I think his amendment to this rather bad motion is at least an improvement.
Well, there's no better endorsement than that, Madam Deputy Speaker, as far as I'm concerned. So that will do for me, and I'm sure that will do for my honourable friend for Amber Valley too. But I want to speak to Amendment C, Madam Deputy Speaker, where there's been an indication on the amendment paper that it's expected to be called for a decision, and I hope it will. It was actually tabled by my honourable friend for Christchurch, who can't be here because of all the parliamentary business that he is engaged in today. But I have signed that amendment, Madam Deputy Speaker, and therefore I would be prepared to move that amendment. And this comes back to the point that my right honourable friend for Staffordshire Moorlands made, and comes back to this point that this motion was sort of cobbled together with a different original purpose, and this is about proxy votes. And the amendment that I've signed along with my honourable friend for Christchurch would be to remove proxy voting for somebody who is subject to charge. And I don't think there's any justification at all for somebody who's been charged with a serious sexual offence or a serious violent offence to be given a proxy vote when people with far better reasons for being absent from the House, Madam Deputy Speaker, are not given that privilege. It would be an outrage, in my opinion, if they were being treated more favourably than other people who had just as good a reason for not being here. And I very much hope that the Leader of the House will accept this amendment, Amendment C. And I actually think it is the mood of the House that this should be accepted, because I think it is a step too far, and I think it is just a consequence of not actually amending the motion when the decision was changed to go from arrest to charge. Look, Madam Deputy Speaker, there's a lot more I'd like to say. I did last week say that this debate wasn't long enough for the seriousness of the issue, and I still maintain that. But I want to allow other people to speak. But what I would urge colleagues to do today is to agree with even though I completely understand and agree with my right honourable friend from North East Somerset that this is an unsatisfactory process, and I suspect if he wanted to vote against the whole motion, I'd have a lot of sympathy with him in doing so. But if we accept the motion as it is, I hope people will accept that charge strikes the right balance in terms of being fair to everybody, including our constituents, who are the most important people to think about in this House, as well as the people, as far as the right balance to safeguard the people who work here too. But I also hope that members will accept the amendment tabled by my honourable friend and me, that we should scrap proxy voting in that situation, and I think that would at least make the motion better than it otherwise would be.
Jess Phillips.
Thank you, Madam Deputy Speaker. I rise in an unusual moment to agree with the member for Shipley. And to the point that the member for Amber Valley also laid out in in a lot of detail, the reason why the proxy voting, the panel, the other things were originally in the motion was because the motion was originally arrest, and this House did not get a chance to have a vote on it. And I have to say, from the cursory opening by the Leader of the House, it seems like that she isn't even that keen on the fact that this got changed. And so I rise to talk about her original motion and the original motion of the Commission, which would, and I agree totally that once all those things are gone, that absolutely, if it's charged, get rid of all the proxy, etc. Yeah. I agree. I absolutely will give way.
Lady, and on the spirit of consensus, may I point out to the House that when I responded to an intervention she made last Wednesday, I made an error where I said that I was not aware that the words arrest had been included in the original proposal. I then immediately rushed off to check that I was right and found that I was wrong, and I'm glad to have the opportunity to set the record straight.
I absolutely welcome the honourable gentleman's intervention, and also totally agree. And actually, in the spirit that I was seeking to correct him, I hope he took it in the spirit that it was intended. I will say, it does somewhat point out that on the issue of arrest and sexual violence and safeguarding, I am usually right. So just you know,
be humble about
yeah. So today, just on this one day, I've spoken to 2 women who were raped by members of this Parliament. 2, just today. That's a fairly standard day for me. And I noticed that these are not the people who've so far been mentioned much today. And some of them told me what they wanted me to say today. So I will just read out, actually, some of what they sent to me. So the exclusion at the point of charge sends a clear message to victims that not only will we not investigate unless a victim goes to the police, but we won't act unless they're charged, which happens in less than 1% of cases. Exactly. So what's the point, was essentially what this victim said to me. And I wonder if the Honourable Lady from the Procedures Committee, who told us of all the people that she had in front of her, how many of the victims of these crimes came and gave evidence, or were given an opportunity to give evidence in private? None. And so I am going to stand here and I'm going to speak up for them, because every single one of them wishes for this to be on arrest. And the idea that an arrest can happen on a vexatious charge does somewhat suggest that nobody in this building who has said that has ever dealt with an arrest in a case of sexual violence or serious violence, and that this amendment to make it arrest, it happens to be in the name of somebody who, as we've already shown, is always right on this, and a former police officer who I would urge the House to take... I know we're not always keen on experts, but I would urge the House to understand that it takes a huge amount for somebody to be arrested. You can't just ring, like West Midlands Police, and say, Jess Phillips assaulted me, and they're going to come round and arrest me within the hour. What world are we living in? This is absolutely madness that we think that we don't trust the police officers in our country, is what we're saying if we don't do this at arrest. And so to the member for Christchurch, who, by the way, isn't here today, and I have informed him that I will mention him, as he was laying his amendments, which if the one in our name falls, I will absolutely vote for, so it's not a particular criticism of him. I asked him, I said, what about safeguarding, when we were both tabling our motions? And he said, but the thing is we're not employed, and so employment law doesn't come to us. I said, would you like this? I asked him if he had children or grandchildren, and I said, would you like this in your child's school? If one of the teachers had been arrested for rape, and they'd go and teach your kids? And he said, the thing is we're self-employed. So I said, OK, childminders, they're self-employed. Happy with a rapey childminder who's been arrested? Looking after your 3-year-old? I'm not. Why do we think we're so special in here? Why are we all talking as if all the people who work in this building don't have a right to feel safe when they walk around? The women I spoke to today don't feel safe, and they told me to come and say it today. The women who work in the office on my floor all said to me, go and say this for us, Jess, today. Why do we think we're so special? And to the member for Christchurch, who I noticed today, his constituents are completely bereft of representation. The arguments that we're taking away our constituents' rights does somewhat suggest no one in this building should ever take a day off on the slip. Don't be going on holiday. What about your constituents? I will.
First thing I think we should acknowledge is that my honourable friend for Christchurch is on a parliamentary delegation, and so he's not being slipped in the sense that he's not on holiday or whatever, and I think it'd be wise if she would reflect on that. The second thing is, given the passion with which she's spoken, which we all accept and we all agree about the victims, if somebody was arrested for a serious sexual offence, would she agree with her honourable friend that exclusion should be the last resort, or would she think that they should be automatically excluded?
I guess it would entirely depend on the sexual offence, but I can recognise enough, even though I jokingly said I'll be on the panel earlier, I can recognise enough my own particular bias in this regard. No, I do think exclusion would be the answer, but so too will most people, is the truth. But the idea that, which, you know, I understand, and to the point that I was making, on the point of the member for North East Somerset, this chamber is where we represent people. Well, are the member for Christchurch, I'm just using him as an example because you said that he wasn't here, or anybody else, are their constituents bereft? Where are all the people who are in here now, are they not being represented? So this argument that keeps being done, I'm doing it for my constituents. I bet you I could find people in every single person's constituents who don't think that they're being represented particularly well. I will.
I'm sure she must recognise that there's a very great difference between not attending one particular debate and being excluded from Parliament for up to perhaps 2 years or so. I'm sure she must realise that there is a great difference between those two things in representing your constituents.
The trouble is that is what is currently happening. That is already happening. Now, if he would like to join me, or anybody who doesn't want it to be 2 years to wait from arrest to charge, to join me in all of the advocacy that I have been, you know, before I was in this building, when I worked in this field, it wasn't 2 years between arrest and charge. So maybe the Leader of the House could reflect on her party's own record in this regard. Of course, it shouldn't take that long. Of course it shouldn't, and I think it was the member for Amber Valley said that if it was quick, and we all want to see that for everybody involved. But the idea that we are some sort of superior beings who shouldn't have to be concerned about safeguarding laws that are totally standard practice, across the whole of the country. And do you know who gets excluded now? The person who got raped. That's who we exclude now. We say, this magical being has to be able to stay because in 1348, blah, 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 blah. Like, what about the person who got raped who works here? I will give way.
This should be done properly. I think the Honourable Lady makes a compelling case for arrest, but only if it's done in a proper and constitutional manner.
I wish that I knew anywhere. Like I say, I'm often right on these things. I'm going to err to his judgment on that because what I know about the things, and I don't mean to besmirch him, what I'm saying is we seem to act like we are some sort of superior beings. And the people who currently get excluded are often young women who never, and I've dealt with cases where it was young men, who never work in politics again. The woman I spoke to first thing this morning has never stepped foot in this building again. She has given up politics. We have extinguished that light. We gave it up. We excluded her. And we allowed the person she alleges to have done that to her to walk around, and everybody who votes against the arrest would be willing to allow that person to walk around, possibly being a danger to somebody else, for another 2 years.
Now, I have 3 more speakers. I need... nothing wrong with interventions, but I would be grateful if speakers could stick within the 7-minute period, because otherwise it gets to 10 minutes and we won't have time for the Minister. Sir Michael Ellis.
Thank you very much, Madam Deputy Speaker. And I rise to support the Leader of the House's motion, and it's a pleasure to follow the powerful argument made by the Honourable Member for Birmingham Yardley. I speak as a former law officer of the Crown, a former Attorney General under 2 Prime Ministers and Solicitor General before that, but perhaps more relevantly, as a practising barrister in the criminal law field for 17 years before I was elected to this Honourable House. And I very much accept a need to protect the people working here. Of course I do. And that includes other members, it includes all the staff of the House, it includes staff of members and everyone else, and visitors. And I personally prosecuted cases, and I think I'm the only speaker today on either side who has actually prosecuted sexual offences and defended them in court over a 17-year period before 2010. So I care about these issues from a professional standpoint, and I'd like to speak about that aspect, but also about the constitutional aspect. And I agree very much with my friend from North East Somerset. After all, Charles Bradlaugh, who I think he referred to, was the Northampton MP in the 1880s, and he was excluded from this House repeatedly for refusing to swear the oath at the time one couldn't affirm. And that's a constitutional point about how the House maintained its rights to reject someone who had been voted to serve in this House. But there is a key principle here. There's a golden thread that runs through our system, that a person must not suffer imposition before guilt has been proven. And it is offensive against the laws of natural justice and, in fact, contrary to human rights to do so. There is a principle, and this principle is ancient. It, in fact, dates back to the ancient Romans, and later than ancient Rome, the 6th century Digest of Justinian cited the general rule of evidence, which I was taught 30 years ago in my law degree, which is that a person is innocent until proven guilty. And everything we do in this House must be based and predicated on that principle. Proof lies on him who asserts, not on him who denies. And that's based on the legal principle which is found in Latin, incumbit probatio quae dicit non quae negat. When it was referred to, Madam Deputy Speaker, in the 500s AD, so over 1,500 years ago, it referred back to Roman times. That's how ancient this principle is. It was actually introduced in Roman criminal law by the Emperor Antoninus Pius. It has become part of the constitution of this country. So what we do in this House is predicated, as the member for North East Somerset has said, on our constitutional principles, and as the member for Rhondda will also know as a historian of this House. But it's not just that ancient, it's important. Even the Hebrew Talmud has said that a person is innocent until proven guilty. And I've read the presumption of innocence is fundamental to Islamic law. The principle that the onus of proof is on the accuser or claimant is strongly held, based on a hadith documented by the Imam Nawawi in the 13th century. So everything we look at here, whether it be Blackstone's commentaries on the laws of 1760 that now are still taught today, it is better that 10 guilty persons escape than one innocent person suffers. And having spent 17 years at the bar, practising in criminal law, prosecuting and defending, before being elected to this place, I would strongly agree with that sentiment. And I'll give way.
I'm grateful to my right honourable friend in giving way. I also prosecuted and defended in criminal courts before coming to this place. And I accept, of course, innocent until proven guilty, and have dealt with a case where individuals have been accused and then been found to be not guilty at the end. So I say the question to him on the constitutional point, which has been raised before. If the constitutional point is that this is unconstitutional, then after that everything else falls, doesn't it?
He makes his point, and I'm conscious of the Deputy Speaker's admonition as to time, so I'll move on. But what I would say is this. A constable arresting an individual, the legal test is necessarily very low. A mere suspicion is sufficient. What is called a reasonable belief. That belief could turn out to be wrong. Many people arrested are never charged. In fact, many people who are charged are never convicted. This isn't about MPs, Madam Deputy Speaker. It's about the principles of justice, at least it is for me. And to admonish or to punish individuals from their work in the public interest, which is what MPs, of course, do, on arrest is wrong. It might very well also encourage malicious complaints. And let us not forget there is a history of that. So I'm going to cut my remarks short, bearing in mind your admonition, Madam Deputy Speaker. And necessarily, I wanted to emphasise that although my remarks, coming as they do from a lawyer, are perhaps rather legalistic and constitutional, they're no less passionately held. And I have great respect for those on both sides of the House who have spoken as they do. We all care about justice, and we all care that right is done for all, and we care about victims to be treated properly. But we must avoid, in my respectful submission, breaching long-established rules of natural justice, which are part of our Constitution. Otherwise, history will look back on us, as they do other periods of historic unfairness and injustice. We must maintain our historic fairness, and I therefore support the Leader's motion.
Justin Mathers.
Thank you, Madam Deputy Speaker. I rise to speak in support of the amendments put forward by the Honourable Member for North East Fife and remind the Chamber it's now almost 11 months since the proposals on risk exclusion were first debated in here. And it seems then we've had a lot of discussions outside about how to best to protect everyone who works here. And I think there is a general acceptance, constitutional issues aside, that something does need to be done, but there is a clear disagreement about the threshold for intervention. And I think it's clear there is a need for a threshold for an assessment to take place, and we are talking here about a threshold for an assessment, not a threshold for an exclusion, which is why I support the amendment that it should be the threshold should be arrest rather than charge. After all, if there has been enough evidence gathered to charge someone with a violent or sexual offence in almost any other workplace, there wouldn't be any discussion about suspending that person. It would just happen. And that's because most employers in this country believe providing a safe and secure place of work for their staff is a given. And I think that's the place the Honourable Member for Amber Valley has come from in terms of his amendments. In fact, I have the view that actually most workplaces suspension would happen automatically following arrest. But that amendment that I support doesn't actually go that far. It just says that arrest is the point that we should begin to consider the risk to the people who work here. And that is the key point to this, Madam Deputy Speaker. We're actually thinking about the risk to the people who work here. And as my honourable friend, the member for Birmingham Yardley, very eloquently put it, you don't just bring up the police and get someone arrested on a whim. There is an awful lot more investigatory work done before we get to that point. So this is about striking the right balance between ensuring people are able to work in a safe environment and ensuring that the people members represent do not feel disenfranchised by virtue of a member's absence. But in terms of our constituents' views, it isn't just how a member represents them in here. There are lots of other things, as we've talked about, that can be done outside of this chamber to represent people. But there is also the other side about how a constituent would feel if they wanted support from their MP because they were working in a place that wasn't dealing with a sexual predator and they had to go and see that perpetrator every day they turned up to work. Turning up to work anxious and fearful that they might bump into them. And for whatever reason, the employer was not allowing anything to be done about that because the police have not formally charged that individual. I would hope that we could all see how that could put the victim in an impossible situation. But how could we support our constituents to insist that the employer do the right thing if we don't insist on doing those things ourselves? If we can't get our own house in order, how can we effectively challenge the very worst employment practices out there? And shouldn't we be aiming, Madam Deputy Speaker, to be one of the best places for people to work? We cannot hope to recruit and retain the brightest and best in this country if we have a working culture from another era. And of course, this is a very special place to work. It's a privilege to be here. But that doesn't mean that we should have to put up with suboptimal standards in terms of how we conduct ourselves. Exactly. We should aim for a culture where everyone is respected, working conditions are amongst the best in the country, and when those standards slip, we must ensure there is a robust and swift process in place. And one of the objections to some of the amendments that we were talking about seem to be that members shouldn't be subject to the same rules and standards that we hold other people to. I believe that's wrong in principle, and it just feeds into the sense that a lot of people out there have that we're out of touch with the real world. And I also feel there is some conflation, possibly deliberate, between the use of this procedure and the finding of guilt. I would never accept that an expulsion or exclusion equates to a finding of guilt. This process will not replace the role of a court, and I believe the risk assessment process and adjudication panel that has been suggested would deal with this in a sensible and considered way and would have an ample opportunity to weed out vexatious complaints, although for the reasons I've already stated, I don't think we would even get to that for vexatious complaints. What we're actually asking for here is for something to be done that we're not asking anyone else outside not to do. We're asking for the same standards to be applied here as in every other workplace. And the original report on this stated very clearly that flexibility is the key. Mitigations can be put in place that fall short of exclusion. There are lots of different examples of that. From the member for Rhondda gave a number of issues and measures that could be taken before you reach that last resort of exclusion. That's what any other workplace would do. They would look at the risk, they would assess it, and they would take mitigating steps. But I'm afraid we're into a very binary debate about whether this means we should exclude or not. And there's a number of different ways we can protect our staff without having to reach that point. But it shows us again, I think, that this place believes the rules don't apply to us in the same way they apply to everyone else, that we don't value the victim's voice, that we don't believe people in here should have safe working environments. They should have confidence that they can work in a safe environment. The public should look at us and think about whether we really do value the contribution of our staff by putting them into these positions in the first place. And I'll just finish with the words from Dame Laura Cox, whose work really sort of started this whole process. She said, "This place has a culture of deference, subservience, acquiescence and silence in which bullying, harassment and sexual harassment have been able to thrive and have long been tolerated and concealed." And I think we have made progress in dealing with that, Madam Deputy Speaker. I'm afraid some of the arguments I've heard tonight have said some people just haven't understood. We've got more to do.
Stella Creasy.
Thank you, Madam Deputy Speaker. Let me start by saying, actually, I do agree with the member from Somerset who's on his phone about this should be a constitutional issue. I agree with the member from Shipley about the daftness of some of the ways in which the system interacts, and the member from Amber Mills. This is an imperfect proposal, but it is now over 7 years since we started talking about tackling sexual harassment and sexual abuse on the estate. When we heard that there have been rapes and sexual assaults in this building and through people being involved in politics and by our colleagues and allegations of such. So the answer for us all tonight is, do we keep doing nothing? Or do we take some action and make some progress? Because my colleague from the Rhondda is right, it isn't about exclusion, it's about that word risk. What are we doing about the risk? A risk that we tell other workplaces they have to act upon. So yes, Madam Deputy Speaker, I won't use the term hypocritical, but I do think double standards, inconsistent, inexcusable, unjustifiable are the risks for us if we do not match the ambitions we set for other workplaces here for ourselves. And I say to every MP in this House, you should want this to be the case, because whilst we don't have an employment contract, you sign employment contracts for your staff. And therefore, the laws that exist about what responsibilities you have as an employer apply to how you treat your staff and whether you can truly look them in the eye and say this is a safe workplace. And in a workplace where our young women employees get taken out by each other to be warned about other MPs and indeed staff in this place, the Whisper network, that would not cut it at an employment tribunal, let me tell you. So policies like this are about living up to what we expect of other workplaces. They're about the point where somebody comes into your constituency surgery and says, well, hang on a minute, the local head teacher's been arrested, but they're still teaching children. There's a surgeon at the hospital who's been arrested for sexually assaulting a patient, but they're still in there. What are you going to do about it? And you turn around and say, well, hang on, until they're charged, I don't think there's a problem. We wouldn't be able to justify that to our constituents. Why on earth would we justify it about ourselves? The idea that people are arrested on a whim, they're not. And it comes down to something so central. The cognitive dissonance in this place, that we have constant debates about violence against women, how we're going to tackle it, make it a priority, recognise that we too often don't believe victims. But we're saying in this instance, because we're special sausages, that won't be a priority. We have to start believing and acting on those beliefs. And it may be an imperfect process, but finally it's a way of saying we do believe. Sadly, power corrupts. Sadly, there are people who abuse their power dynamics and their power relations. To understand that, as the consultation that prejudged this said, gentlemen's agreements for what should happen are insufficient. And yes, political parties, the elephant in all this debate today, are complicit too. Cosy wrap-ups with the Whip's office to try and manage situations, when every single person who's come forward pretty much has lost their job. A job they loved, in a career in a party they cared about. We don't protect the victims, we protect the perpetrators. Every political party needs to look itself in the eye and ask why 7 years on, people are saying the IGSCS process, which is imperfect in its own way, is still better than our political processes. And it's debates like this and the different standards we hold ourselves to compared to what we expect in workplaces and our constituencies. In fact, the standards we should apply as MPs ourselves, as employers, that are the issue. And if nothing else, the fact that we have demanded of the police, in order to keep people safe on this estate, that they bar from this estate anybody accused of a serious violent or sexual offence, not even arrested, not even that women, I'm sorry, the member is no longer in his place, that he says is so easy to get, even just accused. We've asked for those people to be barred to keep us and our staff safe. But we don't ask that of ourselves. Inconsistent, double standards, contradictory, could be potentially beginning with the H word. Above all, it damages our reputation. This is a workplace where you have unparalleled access in your constituency to people because you're the MP. You don't have to have a DBS check. No. This is a workplace where nobody is asked to tell HR if they enter into a relationship with somebody. Yet in most workplaces, that's a really standard thing. And frankly, it protects people because it recognises the difference between a power imbalance and actually the inevitable love that sometimes comes as a result of delivering too many leaflets on too many long weekends. This isn't a workplace in the modern world, and our staff are suffering as a result. 7 years on, the cases keep coming forward. 7 years on, the cases are being covered up. 7 years on, people are losing faith that we will ever get it. So yes, this proposal is not perfect, but this proposal is a step forward. And if people don't vote for it and vote for Amendment O, to get back to what we originally talked about, which is recognising if somebody is arrested for a serious sexual or violent offence, then that does mean a risk analysis needs to happen. Don't sit in that surgery and someone comes and asks you what they should do about their workplace. Don't tell me that you're listening to victims of sexual violence, that you understand why violence against women and girls in this country is still such a problem. Because we're not so special sausages that we can't be complicit in that culture. And that's the risk tonight if we don't vote for Amendment O and we don't try and at least get this process rolling. It's not perfect, it can be amended, but if we vote it down tonight or we try and find a way of making it basically impractical to apply, our staff will not forgive us. Good, talented people will walk away from politics because it is a dangerous environment, and our constituents will simply not understand why we don't hold ourselves to the standards we ask of them as employers and other people. For the sake of all of us, special or not, sausage or not, let's do something finally about this. Let's put safeguarding at the heart of what we do, and let's try and move into the 21st century for once.
Leader of the House.
Thank you, Madam Deputy Speaker. And can I thank all honourable and right honourable members who have taken part in the debate tonight. I'm going to try in the limited time I have to answer the technical points that honourable and right honourable members have raised. The first was from the Shadow Leader of the House that just wanted me to confirm that if someone was currently under charge, would these procedures, if we bring them in today, apply to them? And the answer is yes. And indeed, if there was new information that came to light, having someone been charged, this process, the panel could be reenacted again. So it's a risk-based approach and would apply to people who are currently under charge. The honourable member for Runnymede and Weybridge asked, does this apply to all members of the House, including the Speaker and Deputy Speakers? And it does. And if they were panel members, they would clearly recuse themselves as they would in other scenarios. The Right Honourable Member for Staffordshire Moorlands and Chairman of the Procedure Committee, can I first thank her and her committee for the work they have done on this. I thank her for the support for the Commission proposal and understand her concerns about proxy voting. I would just say to her that we had some evidence, I certainly had heard from constituencies who had members of Parliament who had been out of action, if I can term it in those ways, for some time. And I think it does have a devastating impact on constituencies and communities, and goes to the issue that many members have raised this afternoon, which is about the length of time that these things take and how poorly served people are in that respect. And the Honourable Member for Shipley, who was speaking in part on the Right Honourable Member for Christchurch's amendment, which I can confirm you'll have the opportunity to vote on tonight, also raised the issue of the proxy scheme. Many members raised the comparison about the profession that we are in and other professions, particularly the police force. And of course, the police themselves may be also subject, not infrequently, to vexatious claims made against them for all kinds of reasons. But I would say the volume of members of both houses that have come to see me during this process who have been victim of vexatious claims was surprisingly large. Can I make some progress? And I will allow interventions. I just want to get through the points that have been made. The honourable members for Edinburgh North and Leith and Gillingham and Rainham have been talking about what the government is doing. The government is here facilitating a debate, and I'm glad that this is a genuine debate today, and it's an important matter. But this is a proposal from the Commission that has been discussed on a cross-party basis. The Right Honourable Member for Orkney and Shetland talks about the legal differences between Scotland and England. There are differences between the English and Scottish legal systems, but in both systems charges are only brought when there is a reasonable view that there is enough evidence that that person has committed a crime, and therefore in both systems the risk-based exclusion scheme would be triggered when enough evidence has been obtained, and it would be consistent. The Honourable Member for Rhondda raises a variety of points, and of course this is one option. It's an option that Mr. Speaker and the Commission feel that this House should have. But clearly there are many other things already in existence that could safeguard individuals, both in terms of voluntary, but also in terms of powers that other people have on the estate. For example, Sergeant-at-Arms and others in excluding people from bars and obviously other things that can be put in place to safeguard staff. On his particular point with regard to prorogation and also dissolution, it wouldn't apply in those cases, but with regard to the former, it's a very short period, so it was viewed that there wouldn't be a practical impact. Again, this can be reviewed in the 6-month review that is proposal. And of course, in dissolution, it wouldn't, but it wouldn't be needed because people would be off the estate. I will come to him. Let me just crack through the other points. The Honourable Member for North East Somerset, I think, gave some examples that slightly misunderstood what the scheme is doing. We were not talking about a member being expelled from the House or losing their place as a member of the House, but excluded from the estate for a limited period of time. And it is for Parliament, in accordance with the principle of exclusive cognizance, to organise its own affairs, and it is orderly, therefore, for this House to consider the proposals in the way that it is. He invites us to consider a scenario where a member of Parliament resigned as an MP and then stood for re-election, and asks whether this process would still apply to them. If they were still under charge, then yes, it would, and I will come to him once I've been through the points that have already been raised. The Honourable Member for Amber Valley, I thank him for his attention to this and giving the House the option to vote on his amendment. When the Commission was looking at this, we did look at potential scenarios, although not at charge but at arrest, where someone might be arrested for, say, a violent offence, but it would not be deemed appropriate to exclude them from the estate. So one of the examples we looked at was somebody that was a victim of domestic abuse. So I think that is where that particular line comes from. The Honourable Lady for North East Fife, who has great experience in this area, and the Honourable Member for Ellesmere Port and others talk about a raft of issues related to arrest. One of the issues that did arise when people were looking at this is it's a very obvious question. If bail conditions haven't been applied to an individual, is it right for a panel to, if you like, impose their own? And it is, I think, a small number of situations that the panel would be faced with, where bail conditions and restrictions would not have been placed on an individual, where they felt that with regard to the estate, further restrictions would need to be looked at. And she raises a very important point about charge versus arrest, and the arguments that were forwarded for consistency in terms of charge. I offer them just for the sake of thoroughness of debate. Is that a criminal investigation is commenced where there is reasonable grounds to suspect that an offence has been committed. A person can be subject to a criminal investigation right through to the point of charging without having been arrested. The police will only arrest if it's necessary to do so, but of course they do in a whole variety of cases. And the argument put forward against the amendment would be that it would create a distinction between, on one hand, an MP that has been arrested because the police considered that it a necessary procedural step, and it should be kept in mind that arrest doesn't indicate the allegation is more serious or more credible. And, on the other, an MP who is investigated for an offence at the same level of seriousness, but where the arrest was deemed unnecessary. And I want to come to the points that the Honourable Member for Yardley raised, and I'm afraid she's going to find some of my answers depressing. I'll just ask her to brace for that. The first is that, and this is a point my fellow commissioners will back me up, that I've raised, the House of Commons Commission, who is asked to bring forward motions of this nature, is not fully cited on all of the problems. It is, as members of the Commission, we don't have a 360-degree view of all of the issues on the estate. There are clearly cases going on that are in complete confidence. And that, I think, is a problem about bringing forward and asking the Commission to do work of this nature. I think that people who are doing that are the people who are best cited on the whole of the problem. The Honourable Lady and others have raised the charge that we consider ourselves in this place to be somehow different from other members of the population and indeed our staff. And I think that's wrong, in part because of arguments that the Honourable Lady for Walthamstow has made, which I agree with, but also because members of Parliament can be victims in this situation too. And in fact, historically, women MPs have been victims. So I don't think it is helpful to say that there is a divide between how members of Parliament see themselves and others. I just don't think that is true. Even more concerning for the Honourable Lady and myself is that some of the most serious cases that we are aware of, and some of the cases that I'm aware of that I find most disturbing and most worrying from a safeguarding point of view, would not be covered by any of the proposals that have been brought forward, including at arrest. So this is not a comprehensive solution to this problem. It is a step, though, towards part of the answer. I will give way, and then I will give way to others.
So the first question I was going to ask her is, all these people who made recommendations that they had loads of vexatious claims, can I ask how many of those ended in arrest for a start off? I imagine it will be almost none. And to the point that she's saying is that because she has heard of cases where the police would never be called and there would be no arrest, we should make it charge, not arrest. I have to say, I'm confused by what she's saying. And if there is such a problem, what's she doing about it?
Well, as I said at the start, there are a number of things that the House of Commons Commission is looking at and others are looking at. We have had a review published today into ICGS to strengthen that, and I have a great deal of sympathy with what the Shadow Leader said about ensuring that that scheme, people are directed towards that scheme, and it improves and speeds up, and the investigation issues, the operational issues are dealt with, because I think that has strengthened the options that people have on the estate greatly. I'm going to also give way to the Honourable Member, and then I'll come to the...
I'm very grateful. I think she said, I may have counted this wrongly, but I think she said on 6 occasions now that this is the proposal from the Commission. But it isn't the proposal from the Commission, is it? It's her proposal. Yeah. If it were the Commission's proposal, it would be at arrest, not at charge.
That's not correct. The Commission, no, it's not, with all due respect to the Honourable Member. The Commission originally proposed arrest. We brought that to the floor of the House. There were concerns before it arrived, and therefore we decided to have a debate, not a vote on it. And the issues, there were 3 key issues that were raised during that debate. The issue of charge versus arrest was one of them, and all 3 issues have been dealt with and looked at by the Commission. The House has a chance tonight to vote on proxy voting, on the panel, on arrest versus charge, and the scheme itself. And it is for the House to decide this. I think it's a sorry situation that the honourable gentleman would paint this to be something it is not, and I think it shows a distinct lack of situational awareness, I have to say. I'm going to go to the honourable gentleman.
To my right, honourable friend. On the point of exclusive cognizance, yes, of course this House, as was established in the Bradlaugh case, has the right to determine its own procedures, but it has never had the right to delegate the exclusion of a member to a panel. That is the responsibility, and always has been, of the whole House. Otherwise, we have a right dating back to 1340 of unmolested attendance, and exclusive cognizance cannot override our ancient rights in that way. We can, of course, expel individual members, and that is the flaw in this proposal.
Well, I thank the honourable gentleman for his helpful point. In addition to what I said earlier, the choice that the Commission had was between retaining the confidentiality of the situation and the advice that the Commission received with regard to not jeopardising an investigation in an ongoing case was very, very compelling, or to ignore that and bring this to the floor of the House. The Commission decided that it would that the former was the better course of action. We do not have very much time left, but I will give way to the honourable lady again.
I just want to know who she received that advice from about confidentiality and what qualifications they have.
So they are the House Authority's lawyers. That was the advice that the Commission received, and that was the course of action we decided to take. But honourable members it is correct. The honourable members have the opportunity tonight to vote on 4 key issues: on the proxy voting scheme, on the panel itself, thanks to my honourable friend, the member for the Amber Valley, on whether it should be arrest or charge, and the scheme itself. It is for the House to decide, and I commend the Commission's motion to it.
I call Wendy Chamberlain to move Amendment O formally.
I beg to move.
The question is that Amendment O be made, as on the order paper. As many as are of that opinion say aye.
Aye.
Contrary, no.
No.
Division, clear the lobby. The question is that Amendment O be made as on the order paper. As many as are of that opinion say aye. Aye. Contrary, no. No. Tell us for the ayes, Colleen Fletcher and Andrew Weston. Tell us for the noes, Mike Wood and Gagan Mohindra. Order.
The ayes to the right, 170. The noes to the left, 169.
Order. 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 The ayes to the right, 170. The noes to the left, 169. So the ayes have it, the ayes have it. Unlock. Order. Order. I remind the House that Amendment H is consequential on Amendment O, to which the House has already agreed. I call Wendy Chamberlain to move Amendment H formally.
Move formally.
The question is that Amendment H be made as on the order paper. As many as are of that opinion say aye. Aye! The contrary, no.
No.
Let me do that again. The question is that Amendment H be made as on the order paper. As many as are of that opinion say aye. Aye! Contrary, no. I think the ayes have it. The ayes have it. I call Nigel Mills to move Amendment I formally.
Not moved.
Amendment I is not moved. So we now come, I call the Leader of the House to move Government Amendment N formally.
Formally.
The question is that Amendment N be made as on the order paper. As many as are of that opinion say aye. Aye. The contrary, no. I think the ayes have it. The ayes have it. I remind the House that Amendment P is consequential on Amendment O, to which the House has already agreed. I call Wendy Chamberlain to move Amendment P formally.
Move formally.
The question is that Amendment P be made as on the order paper. As many as are of that opinion say aye. Aye. Contrary, no. I think the ayes have it. The ayes have it. I call Sir Philip Davies to move Amendment C formally.
Not moved.
Not moved. I now come to, bear with me, I remind the House that Amendment Q is consequential on Amendment O, to which the House has already agreed. I call Wendy Chamberlain to move Amendment Q formally.
Move formally.
The question is that Amendment Q be made as on the order paper. As many as are of that opinion say aye. Aye. The contrary, no. I think the ayes have it. The ayes have it. A little bit of advice. Thank you. The question is motion number 3 as amended. As many as are of that opinion say aye. Aye. The contrary, no. No! Division, clear the lobby. Question is motion number 3 is amended. As many as are of that opinion say aye. Aye. The contrary, no. The ayes have it, the ayes have it, and the division is off. Can we clear the house? The division is off. So I need to move to the adjournment, but I need the chamber quiet so I can do so. And just if there's any clarity needed, the question was put and the ayes had it. So just to be clear, so the division is gone, and I do now wish to move to the adjournment. So if we could ensure that the minister is here.
He's here.
The minister is making his way quickly. Who is it?
You can't, just a minute, just a minute, she's got to find the minister. Who's the minister? Who's the minister?
Lee Rowley. But I am just waiting.